Right. Bismillahirrahmanirrahim. Bismillahirrahmanirrahim. La yadurru ma'a ismihi syai'un fil ardi wa la fis samai wa huwas samiul alim. Uh, Under the syllabus, do you have a syllabus with you given to you? Yeah.
Yes, yes. In the future, they have a syllabus.
Alhamdulillah. Okay. In the near future, if you open up, let me know about the area, the first area that you are, is it, kalau kita tengok Nocaya ni, because we're going to refer, for those yang tak tahu, I'm going to refer 100% dekat Nocaya, right? Trespass untuk talks 1, and then we have of the apa, of the, I rasa tak comfortable lah tengok muka you, tengok muka I selalu. I rasa conscious. Alright, kalau you tengok this so-called Percaya book, kita, is it in line with the course outline? Okay, we are going to look at the occupiers liability. Okay,
Defamation, occupiers liability,
defamation,
nuisance,
yes, nuisance, right?
liability,
And then nuisance, yes, and then we have strict
in
liability,
Rylance and Fletcher. Yes.
yeah, like Ryan and Fletcher, yeah. Okay, we will also study breach of statutory duty. This is towards the end thing, and vicarious liability, yes, this is important that you have to learn. Okay, and then remedies, yeah. Other than that, do we have that? Imaging thoughts tak ada lah,
No.
okay, right. So we are going to do, what we are going to do today is the thoughts of uh, what, 215 is strict liability. Oh no, it's not strict liability. Hold on, defenses to negligence. For those the second edition, so we are going to do occupiers liability. Okay. Now, for occupiers liability, you have learned thoughts one before. Occupiers liability is talking about the liability of the owner of a place, yeah. Uh, Nama pun apa, a person that is owing property, that the property is being given to somebody else, yeah, to own it. Say for example, you have a house that you rent it out, so the rights of the occupiers, meaning the person who rent your house, what would be his or her position in terms of the rights and liabilities, yeah, of the place that he or she is renting. Okay, so we do have the position of law when it comes to trespass to land. Yeah, trespass to land is to be applied to owners of the land. Yeah, so therefore owners of the land have the rights. Yeah, or the one that is in possession. Yeah, in legal possession. Yeah, in legal possession meaning you are the, what they call it, the person who owes, who is holding, what do you call it, Allahu Akbar, uh, a right, yeah, a right to hold that property on behalf of somebody else. So you have the ability to sue someone for trespassing. So here we are going to look at the liability of occupiers with regards to people who enters into their space. Yeah. So with respect to the law statute, we don't have any statute for Malaysia until now, I believe. Yeah. Because the Parliament wants the area to be open for the judiciary to play their active role in order to formulate the area. Maybe in 70 or 100 years from now, they will come up with a law. Yeah, they will come up with a law to regulate the issue of occupiers liability. But for the time being, for Malaysia, we don't have one, because they want the subject to mature. Yeah, how do you mature a subject? By settling problems through courts decisions. Yeah, so that is the position of law. So all the area of decision that is being made is mainly based on common law as compared to statute. Yeah. So uh, what you need to do is, by the end of the semester, when it comes to your assignment, your what they call it, finals, yeah, you, if you are, the question is about occupiers liability, just stick to the common law principle rather than act. Do not ever make that mistake by stating occupiers liability act. Yeah. Uh, because if you were to do so, that is a big indication that you have no idea what you're talking about, right? Um, Here, there is no thoughts of occupiers liability. Hence, plaintiff does not sue a person a defense for occupiers liability. Yeah. Uh, so here, what Nochaya is trying to say is that a plaintiff does not sue a defendant for occupiers liability. And similarly, the defendant is not liable for the thought of occupiers liability. Meaning, if you occupy a space, yeah, uh, the plaintiff, if they were to not able to sue someone for something that happens to them when they are there in that particular space, yeah, that was given to somebody else, then uh, it makes no sense of trespass, or the law of torts, because if that person is not given compensation, then it would not fit into what we call in our federal constitution the right of a person to not be deterred by the law. Yeah. So equity, justice, and fairness is to be given to all citizens of Malaysia. Anyone who is inside Malaysia, for that matter, can have the right to sue someone else if they were suffering any kind of injury or any losses that while they were inside a premise, a given premise. Say, for example, your office is located in building A. So when you are going to work in that particular building, you suffered something of a loss while utilizing the lift. Yeah, the lift that your office might be in the 20th floor. Yeah, so you have to utilize the lift. But while you utilizing the lift, something happened to the lift and you suffer injury. So that you need to be compensated. Other than the law of negligence, yeah, we can utilize this option of occupiers liability. Okay. As I mentioned just now, if you are renting your house to someone else, if someone, say for example, X enters into that house, what will be the rights and liabilities of that person towards X? Yeah? We do have guests that comes into our house. Okay, and what happened if you put, you were negligent in terms of doing something that, causing injury to those visitors that is coming in into your house? You owe that responsibility to the people that is coming into your house. You cannot simply say that it's my house, I can do whatever I want. So if you choose to come into my house, anything happens to you, I'm not going to be responsible. Then it does not make sense. Yeah. Uh, this is where in the paper or the chapter of occupiers liability is trying to highlight, yeah, if you are unable to utilize negligence, because negligence is very tedious. In order for you to prove duty, you have to prove that the person breached the duty, and then the damages that you suffered is because of that breach. It is a very lengthy process. Other than that, you can always apply occupier's liability as a mode to claim from the other person, because it is a faster way, yeah, of us getting the compensation from the courts. Remember, when you suing people in courts, yeah, especially when it comes to civil claim, you can actually throw everything towards that person and expect one of the argument or one of the claim, yeah, that you make, the legal claim that you make is going to stick. Yeah, you can always sue a person under negligence, under thought of trespass, and then occupiers liability, and then you hook vicarious liability into it. There's so many things that you can sue or use in order for you to sue, and the most is that the court is going to give you only one. Yeah, you can add in contract, into the argument, into the claim. So breach of contract, breach of negligent negligent, yeah, negligent act under duty of care, and then you use occupiers liability to sue someone who is the owner of the land, owner of that space, but only one that is going to stick. So it is up to your lawyer, or you become the lawyer, to put up the analogy dia senang ya. It's just like using a pistol to shoot someone or using a machine gun to shoot someone. I think the possibility of you getting that person hurt is better using the machine gun rather than the pistol. Okay. Siapa? Yeah. Any questions that I heard somebody open up? Nick, can you? Ada soalan ni you want to ask? Remember, you can stop me at any time. Right. Coming back to the document, if a plaintiff suffer injury due to dangerous state of affairs, yeah, for example, you have your house, and then sometimes you see houses, they have erected something in order for them to safeguard, put safety measures like road wailer, even though a Muslim family, they opt to have a dog, a fierce dog, in order for them, for the dog to safeguard them. Yeah? So whenever somebody coming into the space, they were injured because of that. Yeah. So if you were to put a dangerous state of affairs, for example, another example that I can give is that your house is a piece of land that is big, and you have a hole that was dig. You have a project of trying to take out the groundwater, from project, and you left that particular hole there, and then somebody who a trespasser, a child, was dia nampak pokok rambutan, buah dia merah menyala. So that particular child enters into your land and then drop down into the drain atau into the hole and injuring himself or herself. So that is a dangerous state of affairs that you can create or mistakenly unable to move that dangerous state of affairs, that anyone of a reasonable manner, a reasonable mind can see that it is dangerous. Yeah. So
sorry.
yes.
Okay. This one about children. Maybe we are not to the topic, but since you are talking about children just now, because that's a allurement. That means like an invitation. But how are we to justify that thing would have been of any interest to that kids.
Yeah.
Because, okay, this is a question that I raised in the future thing previously. It's about how are we going to justify it based on a reasonable man's eyes, or would it be with a children mindset? Because as a reasonable man, you are already a grown up. You cannot determine what the children might want or will or interested in or are driven by that kind of thing. So how are you determining of that kind of things that might interest them?
Good question, because what you are asking is quite advanced in our discussion, right? But since you said really put it out, so let us discuss that. Allurement, whereby the courts, basically we are, for the rest, we are still in the mode of common law. So whatever decision that is pertaining to allurement, meaning having something that tak tahan nampak, because siapa yang budak kalau tak nampak pokok rambutan geram aja kan, because we were once kids, so we know what is allurement. Bila kita tak ada pokok tu dekat rumah kita, kita nampak dekat, which I'm guilty of things that happened when I was young, pergi ambil pokok orang punya buah. So what needs to be done is to be able to identify how the court settle that issue of child. People who doesn't know, they are not matured minds. So how do you cater that? One thing that I can give the answer is what action that you have done in order for you to eliminate or reduce that possibility of allurement. Okay, that is the question that the court will question. Say for example, do you have a fence that you put up? Do you put notices? If you have a dog, a fierce dog, okay, in the compound, do you put a notice that there is a sign of a dog, fierce dog in front? And then do you lock the gate? The question of whether you do a fence, whether you what they call it, you have the gates, where you are supposed to lock, you did not lock. Some people doesn't have gates at all. Okay, like we go to any kampung, you see that they don't have enough money for them to like erect fences, and that is not the culture of orang kampung, just like the one in the UK lah, or Western world. They don't like fences. So, but still the law still applies. You do have to take your precautionary measures. And that
so
yes. Sorry.
In this case, sorry, in this case, that means we don't have to look in the eyes of the children, but instead we are looking at the reasonable man for civility.
Yes.
What can we do as a occupier to prevent that, regardless whether we know what these children might be interested in or not? But as long as we have done on our part, that one will be okay, right?
The reasonable man test is being applied towards the owner,
occupier.
the occupier. Yeah.
Okay.
Meaning we will discuss about the term occupier, who can fit into the occupier. Yeah. So from the reasonable man standing of the occupier, that occupier must foresee, in terms of again the element of duty, must foresee by virtue of a reasonable man test who would come into his land. Okay. Say for example, you have a house, and then you did not lock your house, and obviously who do you anticipate that will come into the house? Just asking you guys. Anybody. Okay, anybody would be coming into the house, and anybody with intention, good or bad intention. You are staying in an apartment, you have a window that you do not lock, and you don't have any grill, and it is widely open for people to come in. uh, the door is locked, but the window is open. Who do you think that is going to come through that window?
You are living a high-rise apartment where
Yeah,
do you
high
manage
rise.
to go there?
Recently, on the 17th floor of our building, two units were broken into, um,
Wow.
theft. So, okay, so people who comes in might be people who have ill intention, yeah, either to come to rob you, to rape you, to steal. You know, when they come into your premise, you owe a duty towards that person, irrespective of their intention. That is the norm.
Yeah,
Okay.
but sir, are we responsible when he fell off from that window? I mean, he suit them well anyway.
No,
For us,
no, that of obviously that is for his own action. That is no allurement element. That is not justified.
yeah.
But if he or she came into the house, yeah, you know, premise kita dah belajar trespass to land, right? You have to determine the boundaries between your house and the not your house, yeah, your property and not your property, occupiers' property and not occupiers' property. For example, you have landed houses. Uh, some of you are having landed houses. The moment 1 inch after the gate, it's no longer your right. Yeah? That is the land belonging to the municipal, whereby anyone can park in front of your gate, yeah, if they want to. But nobody do that. Yeah. But in my situation, I do have a situation years before when I used to stay at apa, what do you call it, landed property. This particular person, in front of my house, my neighbor, somebody came to the house and parked in front of my house. Actually, I mean, obstructing me to come into my house. Okay, so what we can do, you still cannot do anything because it is not your land. Yeah, you don't have any rights. But uh, you can take action by virtue of asking that person to move. Later on, you remember between one house to another, there is a space right in front of the house. Sometimes you have people to park there when it is your space and their neighbor space. Say for example, a third person's park at that particular space, which is not yours, not anyone's. Yeah, it is no man's land. It is the municipal land. So can you take action against that person? Yes, in a way, you can argue and if what I did was, if that person is able to put in front of my house, then I put in right in front of his house. But that was what I did. Yeah, to say that you can do what you want, I can do what I want. Okay, you want you want to fight? Let's do this type of fighting. Okay, that is the nature that. Sorry for rambling, but what I'm trying to say is that if anyone comes into your land, then you have every right to protect the land and you are to be responsible if anything that happens to them. Yeah. So basically that is the nature of occupiers liability. Okay, questions so far? The rest? Ada yang dah lost ke? Tak masuk apa-apa. Remember, when it comes to law of torts, that the decision is going to be made by the judges, meaning the judiciary is going to make that decision. Now, in order for them to make a decision when there is no law, yeah, there is no statute, so they are going to implement what we call tests. Yeah, so law of torts is actually about tests for you to remember what kind of test to be used for this particular situation or this particular tort. Okay, Rylance Satcher dia ada test dia, ya. Vicarious liability dia ada test dia, semua ada test, ya. Defamation dia pun ada test dia, right? So what we are learning is about the test. So before we go into the test, what we are doing is just understanding the occupiers liability. Occupiers liability, just because it is in my head, I just have to throw it out. For example, somebody enter into plus, highway north south. Take for example highway north south, and if that particular person were to do something, that is illegal, that is not utilizing the space for that particular person to do, that is also the ability for the owner to take action against that person. And whenever you are entering into the highway by paying the toll, then the owner of the land, which is the Malaysian Highway Authority, not Malaysian Highway Authority, who owns Plus? I remember siapa ada nama company ni, Allah lupa, yang UMNO ada share ni.
Ada Khazanah.
Khazanah?
Yes, they are partly under Khazanah.
UAM.
UAM, yes. UAM.
Ada Khazanah.
UAM under Khazanah lah, biasalah, semuanya tak menjadi. Bagi benda 100% you can make tons and tons of money pun tak boleh jalan. You fail in doing that. Pelik. Okay, ingat the case you baca Lim Kek Siang and UAM under law of torts, law of contract. Was it Lim Kek Siang or Kapasik?
Lim Kit Siang.
Lim Kek Siang and UAM. So the fight of local standard, whether you have legal standing to sue,
Yes.
to interfere with the contract of government given to UAM. Alright, okay, coming back. So if, say for example, the plaintiff enters into that space that belongs to the occupiers, and that state of affairs of that space is dangerous, or the activity that you conduct in the premise of the occupier, the plaintiff, if he is or she is able to prove that the occupier had the intention to cause injury to him, can claim under the rule of weak consent doubted. So this is
a question. Okay, let's say my neighbor, let's say, it's just a hypothetical, okay? My neighbor has a house, but then full of salmon and everything, and then suddenly came a snake and out of it, and then entered my house, for example. Can I charge him with the occupiers liability of not taking care of his surrounding or his yard or whatever, and it caused harm to me or not?
You have to prove under what we are doing right now, we consent doubted, right? You have to prove intention.
No, snake definitely. He doesn't intend to bela snake.
Okay, dia tak bela snake. Okay, good.
But then the snake, it so happened to exist due to the fact that he never mowed his lawn or whatever, and then it comes to my house and it's just next door. So can I just charge him based on his negligence of occupiers liability, even though I didn't enter to his premises, but something bad came out of it?
No, you cannot.
So
if you were to be able to do that, then you are opening the floodgate. Meaning, because occupiers liability, we are talking about somebody entering into another person's space. So entering is the keyword for occupiers liability. That is the test number one. There must be somebody that comes into the land, like trespass lah. So the land itself or the space is to be defined, yes, and then on top of that we have to determine the person that is coming into the space, entering, not person but entering. The person pun akan jadi isu, the person, whether he is a contractual entrance, whether he is a licensee, whether he is licensed, say for example a postman, or what do you call it, the Tenaga Nasional meter reader, right? So when they come into the house, nowadays they don't do that. They will use binoculars. They don't want to be exposed. But if they were to enter into that space because they are licensed to do so, what will happen to them if they suffer injury? You bela anjing, and then anjing tu pergi gigit dia. So that is your responsibility towards the people that is coming in, that we are going to look into. But as mentioned here in this paragraph, Wilkinson Dalton is more towards you proving that that the owner or the occupier have the intention. Yeah, intention macam mana? Intention, ill intention is better, but intention to not remove something, yeah, that is dangerous is also you can utilize to win your case. But that is under assault, battery, and false imprisonment. If intention cannot be proved, macam mana pula? Yeah, but still a claim can be made under negligence. Yeah. Before 1957, for English nature of the Act, plaintiff was said to have a choice of suing either negligent or by virtue of special duty owed by the occupiers. Meaning, you have an option. Yeah, as what I told you about machine gun tadi, and you can utilize all argument, yeah, legal argument or legal contest, yeah, that you want to pursue against that particular person. You can do that, but only the court only give you one. Yeah, if you were to take action by utilizing occupiers liability and contract, yeah, so the court will choose either one. But obviously, contract will give you more money, more damages, compensation as compared to occupiers liability. Yeah, because they are the standard, yeah, based on who you are. Okay, post the ACTA, post the, not ACTA, I don't want to use ACTA here because you might be confusing with the non-existent of law, proper law for occupiers liability in Malaysia. But we are looking at England. Naturally, the plaintiff would sue under the Act, but since Malaysia does not have such similar act, cases of occupiers liability should therefore come under the thought of negligence. Yeah. So the difference between ordinary negligence claim and negligent claim for occupiers liability rests in the standard of care. Yeah. So here again, remember when you are in thoughts 1, law of thought is a dynamic law. Yeah. Dynamic law ni macam mana? Dia hidup. Dia hidup kenapa? Because dia akan dibuat keputusan oleh hakim-hakim. So hakim-hakim ni orang, bila dia buat keputusan, dia akan kata sekejap A, sekejap B, sekejap C, sekejap D. It is a dynamic, dia boleh bergerak. Yeah? It is just like macam COVID. Yeah? COVID punya apa? COVID-19 punya virus ni, dia dynamic, dia boleh berubah ikut keadaan. Tapi kalau you tengok certain akta that we have, like Defamation Act, it is clear. It is already entrenched into an acta. So you cannot have many variants of interpretation that the judges can do in order for them to interpret the Defamation Act, other than to reduce compensation, because compensation is subjective. Yeah, it is not objective. Okay, so kalau subjective, then here what I'm trying to say is that occupiers liability in Malaysia can form into its own new law or new area of law made by the judges. Yeah, so initially it is under negligence. It can also venture out into an area of its own, like what we are doing right now. Sepatutnya kita belajar occupiers liability dalam negligence, but Nochaya has put it out and put it under one specific area, that we are able to learn this specific area and understand how to claim from someone, because we will end up as a lawyer or a judge, how to give justice, how to win your clients if your clients went into that particular premise and that your client suffered injury because of that. Okay, so that is the mission of the paragraph. So briefly, the occupiers liability arises in institutions where premises are not as safe. Yeah, so premises are not as safe. Right? Your premise or anyone's premise is in question is not safe and should be as what is supposed to be. Yeah. So if you have a house, say for example rumah harta sepeninggalan arwah ya mak ayah you dekat kampung mana-mana, so you leave the house just like that because you don't have the money to maintain the house because it's going to be quite expensive. You just let it be. So if there is that situation, somebody is bound to come into the space, especially we don't have gates, especially when it is not locked. Yeah, and you are going to be responsible for them. Yeah, so this is where it is important for us to realize our responsibility as the owner of that premise uh, to be aware, yeah, that we have to maintain the structure that we have or the space that we have in order for it not to cause any damages for other people. Boleh? That is the definition. Yeah. Any questions?
No, sir, no.
Okay, good. Now let's go to the meaning of occupier. Yeah. If you are looking at the meaning of occupier, because definition is very important. Legal definition of the occupier is important because without the understanding of what occupier means, then you are unable to have a good case. If you are the lawyer taking action on behalf of your client or defending the occupier's space, right? So you must be able to determine what does occupier stand for. So in this particular case, Wheat and Lacon, where the defendant owned a public house which was run by their manager. And in the license that was given to the manager and his wife is to be able for them to use the first floor of the building for their own personal use. Yang biasalah kita ada rumah-rumah rumah kedai. Okay, you look at old towns, you have rumah kedai di mana kat bawah dia orang meniaga and then atas untuk tinggal. So in this situation, the manager was licensed to stay on top. But the defendant had retained the rights to conduct repair works. So obviously as owners to the particular premise, you have every rights to do repairs. Now the manager and his wife received paying guests on the first floor with the permission of the defendant. Biasalah, if you look at Chinese, especially they rent a space or they were given a space. Normally they don't utilize the space that was given. They normally rent out to other people, which is actually a good way for them to get extra income. Okay, what happened was the plaintiff, a patron, meaning a person that is renting, paying guests, had fallen from some steps, from the first floor of the building, and as a result, he died. So this particular person, the plaintiff, wants to take action against the owner of the premise. Okay, so the House of Lords held that the defendant had who is the defendant here? The owner of the public house. Okay, so the House of Lords it went up to the highest court, held that the defendant had sufficient control over the private premises on the first floor together with the manager, and thus the both parties were occupiers and therefore jointly liable. Who is responsible of that space? Now, obviously the manager is trying to run away from liability and saying that, excuse me, this is not my building, so I'm not the owner. So the owner should be paying, but the owner says, excuse me, I've given you the opportunity to earn some money from the space that I give you for free. But at the same time, you are to maintain, obviously, you takkan nak dapat duit, dapat benefit, tapi tak nak responsibility. So the court says, okay, to make it easy, both are the one that is considered as occupiers. of that particular space, and therefore they are jointly liable. Okay, question for that? Now we are looking at the test. Remember, it's all about the test. So the test is occupational control over the premise, i.e. the word that is here that is important is about control. Who has control over that premise? Okay. Control associated with and arising from the presence in the use, in the use or activity on the premise. Meaning, use, siapa yang use in this above case would be the manager, right? And control in terms of the ownership of the premise is the owner. So therefore, it is considered as also ownership. Liability, however, is not based on ownership alone. So in order for us to really determine who is going to be responsible, like 100%, 70%, 50%, and so on, we need to identify control, i.e. the test of control. Control need not be absolute or exclusive, meaning it is dynamic. It depends on the situation. We cannot simply say that if you rent your house to X, X is going to be the occupier. Doesn't mean that it is in that nature. So it is not absolute. It is dynamic, depending on the situation. So here we have one of my favorite judge, Lord Denning. You have to read his judgment. If you were to read his judgment, then you would see how intelligent they are in terms of trying to come up with answers. Because
sorry.
Yeah.
Lord Denning, it's interesting, even though actually the other judges don't really like his finding that much. But I found that he always come up with a creative idea. I mean, other than the normal judges, I think all his findings pretty much creative.
He is venturous. So he likes to venture into areas that is the main thing is to give justice to people, and justice have to be given it properly. You cannot simply just because you think that you want to give justice and you just give them justice because you think so. As a judge, you cannot do that. You are not a person. You you are a judge, so you have to do things accordingly. Because as I said, Parliament are silent. They don't dare to venture into this area, by creating proper laws, proper acta. So here judges have to be creative in coming up with ideas in order to give a so-called solution. So let's look at let's read this. We are going slow for the time being. I don't want you to be pushed. Kita tengah masuk gear 4 lagi, kita baru masuk gear first gear. Let's look at this. I don't know whether you have done macam Jamie, you dah mungkin dah baca, right? But for the rest, I think they are waiting for the momentum of the class. Okay, let's look at this. Whenever a person has a sufficient degree of control over the premise that he ought to realize. Nampak the word used is ought to realize. Ought to realize, if you are the one that is given a space, that you should know that you are in control. Say for example, I'm living for Europe. Okay, bukan COVID lah. I'm living for Europe and I pass you the key in order for you to take care of the house. So you ought to realize that you are in control over the premise that of mine. So he ought to realize that any failure on his part to use care may result in injury to a coming person lawfully there. So anyone that is coming lawfully, you owe that responsibility to make sure that everything is safe. Okay, then he is an occupier, right? And the person coming lawfully is considered as visitor. And the occupier is under a particular duty towards his visitor by using reasonable care. So if you nampak rumah you ada mainan, anak-anak, and then you ada guest datang, and then you do not remove the mainan, then orang datang jatuh, patah tulang pinggul dia. So that is considered as lawfully coming into the house, is considered as visitor. Then you have to take reasonable care in order to eliminate or all the things that is possibility in terms of causing injury. In order for to be an occupier, it is not necessary for a person to have entire control over the premise, as what we can see in the case above. He is in control of the first floor. However, the issue of staircase, the staircase is in between the ground floor and the first floor. So staircase is in limbo. It is a connection between the first floor and the ground floor, right? So the staircase might be not under the control of the occupier. He may share the control with others. Two or more may be occupiers. You have people, apa orang panggil, sewa rumah tapi ada bilik-bilik yang dia ada sublet, we call it in that. They may be two occupiers, or in the case above, there would be two occupiers. And whenever this happens, each is under a duty to use care towards person coming lawfully into the premise. So both, So determination of who occupiers is the one that is able to put the responsibility to make sure that everything is okay in that premise. Okay, depends on his degree of control. If each fail in his duty, each is liable to a visitor who is injured in consequence of his failure, but each may have a claim to contribution of each other. Like the one that we can see in the above case, we have a joint occupiers, but the first floor and the second floor. Why the owner is going to be responsible of the staircase? It is his building, and he has the right to go and do maintenance. So in other words, any maintenance that is going to be conducted in the house would have the access of staircase to be used in order for anyone who would go up to that floor. So he is in control of the staircase. And the one that is the manager who is living on the first floor, other than he is making money from the sublet of space, he is actually utilizing the staircase in order for him to benefit. Him staying there, on top of that, charging other people. So he occupies the space, which is the staircase that is in question. Okay, boleh nampak?
So, kalau what about if actually that staircase, many apartments like you mentioned, that's not right. So that means everybody who owns an apartment in there can be held liable, and on the share basis, or?
It depends. Remember, when it is subjective in nature, control does not need to be absolute or exclusive, but it depends on the facts of the case. Remember, law of tort is about the facts. In your exam, the facts is going to be given to you, so you have to analyze the facts. So how you argue is based on the decision of the case. So say for example, I just give you an example. If you come into a building that your office is on the 20th floor, right? Just now I give you one example. You enter into that lift. So who is in control of that lift?
Is the management of whoever doing the maintenance?
Yes, the management that is, the management, right? So the management is in control. Are you as the, what they call it, tenant, responsible for the lift maintenance?
Indirectly, yes, you have to pay the maintenance fee, but the thing is that the one who's taking care of whether it's workable or not would be the maintenance.
So it depends on how you argue. Remember, guys, you are going to be lawyers. Hopefully lah. If you end up becoming a lawyer, it depends on how you argue. Okay, law of torts is what we call a civil suit, right? When it comes to civil suit, you belajar the MLS, right? If I'm not mistaken, you belajar your foundation papers, right? It is all about argument. You have a better argument than the other person, then the court will favor you, with you, right? So the most important thing is for you to understand, and once you understand, you can manipulate in terms of the facts that is given to you. It is art of argument. So whether you argue in a way that is acceptable by the judge, and the judge will favor you. So the most important thing here is about argument. Yeah. So exam is a mode where you are going to be asked. Now I just look at this SA. Suppose SA. How if you set a trap in your area? Good question. If you set a trap in that particular area, you are going to be responsible. You are going to be responsible for that trap. Yeah. If yeah, you cannot. Actually, the law doesn't allow you to take laws into your own hands. Okay, who give you the right to, you know, I said recently to the management, I said my house has already, somebody has entered into my house. That person or persons stole our phones, our laptops. Yeah, even though the building have what do you call it, guards, yeah, and CCTVs and so on. So okay, I was frustrated and I said that if I were to court that particular person again, I will make sure that he will lose one of his fingers under hudud. Okay, demi Allah, I will do it. Because the thing that I was angry, because you feel, now I feel how people, women are being raped. You know, when women are being raped, you feel apa ayat ni English ni tu, you feel, Jamie, apa kita ayat tu? Not to say that you are being raped, but the notion is what? Bukan abuse. Yeah, there is a word that is not in my mind right now, but you rasa macam rasa, ialah, you have that feeling, diceroboh, diceroboh in English is what? Ceroboh, you rasa diceroboh, so sama dengan orang masuk rumah kami rasa diceroboh. The anger is still intimidated. Not intimidated, it's worse than that.
Intruder, if someone ceroboh your place, the person is
Yalah, ceroboh tu ayat dalam bahasa English, dia ada a victim or rape victim feel what? Dia akan rasa apa tak? Apalah, whatever. Violated. Nah, that's a word that I want to find. Violated. So you feel violated. Yeah. So the same thing in for my house, that I feel violated. You want to take action. So by taking action, do you put in traps? Cannot. Yeah. You cannot take action against someone, even though you kata nak potong jari dia. It does not happen yet. It is illegal for you to do that, right? But still, you cannot put a trap, bubur pacak, buat kayu, lepas tu pasangkan paku-paku, you know, kaca-kaca. You see houses kadang-kadang dia letak dekat apa, pagar you bubur kaca-kaca. That is okay for you to do that. Okay, but inside, yeah, once people cross the fence and they jump in, and then tiba-tiba kat bawah tu ada lubang ke, ada anjing ke, ada paku ke, you know, things like that. You cannot do that. Okay, that is you cannot use the trap, yeah, because you are not entitled to punish people. Yeah, but is it not fair? Yeah, it seems that it is not fair, but you have to take precaution lah. So you have to, macam saya sekarang, saya letak CCTV. On top of that, saya letak the lampu yang sensor, so anyone comes and then they will light that up. And then on top of that, my grill ada 4 padlock. Yeah, padlock against each other. So so dia nak kena buka satu, dia kena buka 4. Alright. So Dia padlock
So,
senang sebenarnya nak buka Razif nak buka apa padlock. But kalau dia nak masuk memang dia akan masuk. It's just a matter of trying to do something that you want them to delay nak masuk, ya, ataupun rasa tak payahlah kot, pergi cari yang satu padlock lah daripada you tahu tak yang clamp ada tempat lubang untuk satu kunci. So saya clamp lagi kunci clamp yang tadi tu lagi satu kunci. Saya clamp lagi. Ada diamond. Saya dengan isteri saya adalah diamond untuk can you imagine my PhD was inside inside the PC. It was stolen. Luckily kami belajar macam mana nak pakai Dropbox. You know, otherwise ya Allah, I can't imagine me spending time buat research tiba-tiba hilang. And some people nowadays they curi yang tu, then they come back and demand ransom. I saw you have some pictures inside here, which is which is something that is you want to hide. Okay, give me money, otherwise I release it. You have certain document that is important to you. You want it back, I can give it back, but you give me money. So many things that they are doing right now. Okay. Soalan tadi intimidated ya, GMB ya, okay, right, boleh ya, SA, right. So any questions that you want to ask, remember please feel free to put it up. Boleh? Ada soalan?
okay, sir.
Okay, right. We are going to continue. Let's look at the occupier is therefore someone who has the immediate supervision. Yeah, this is by definition. Yeah, immediate supervision. You have to remember this in terms of definition. Before you start answer occupiers liability, if there is a question in exam, what you need to do is to define. Yeah, occupiers is the person who have immediate possession or supervision and control, yeah, and the power to permit or prohibit anyone from entry. Ada kat situ immediate supervision. Immediate, kenapa tak ada supervision saja? Kenapa nak ada immediate? Sudah. Dia ada benda yang kita kena discover apa maksud immediate. Supervision dah ada lebih kurang ke atas supervision yang kita ada this case, the case of Witt and Lacan. So that is supervision. And then on top of that control, control pun juga ada ke atas, supervision and control, and then power to either permit or prohibit people from coming in. Say for example we have macam toll, toll, ada dua yang selalu jadi kontroversi. My wife selalu bising, you ni duk bising je, because she is a lawyer. Dia menyampah, kami selalu argue about law. You ni asyik duk bising je, you write down lah, you write a paper and pass it to the newspaper, the rights of occupiers liability, in terms of people coming into the highway, especially kita nampak hooligans, that is why I don't like riding my bike with group, because I hate group in a way that dia orang menyampah kita. Because when they enter into the highway, this group of people, riders, dia orang kan clock the road, and then dia letak dia orang duduk riding belah kanan, dua lane dia duduk belah kanan, and then people yang bawa kereta ni, they have every right more than the riders, because they are contractual entrance. Kereta bayar, yang motor tak bayar. So the responsibility of the owner of the highway towards the motorcycle is lesser as compared to the one that is paying money. So di situ kita kena tengok, kalaulah kata you dah masuk sebagai entrance that is that is allowed, secara ihsan by the management of the the highway, then you cannot do things that is not your right to do so. So tak faham, dia orang tak faham undang-undang.
Sir, that's the understanding is actually contradict to the real thing, because the bigger you are, the more liable you are carrying the liabilities. I mean, kalau you are a car and you're bigger than the motorcycle, it's not based on who's paying and who's not. That's a point.
Yeah. The road road transport or when you go to court, the assumption that the court will do is that since the bigger is responsible to the lower, meaning abang kena jaga adik lah, so bapa kena jaga anak, you know, that rule, yeah. So the bigger you are, as I already mentioned in talks 1 kan, kata trailer compare dengan lori biasa, lori trailer dia ada kepala putus kepala boleh pusing kan. Lori yang kepala tak putus yang standard, and then lori yang semakin kecil, and then we have van, and then we have cars, and then we have, you know, sampai yang paling kecil, adik yang kita yang paling kecil adalah orang jalan kaki lah. So that is one, the one thing that the law will look into. But under the law proper, occupiers liability, entrance of the category of entrance can be divided clearly by virtue of the money that they pay or the permission that they receive, whether they are licensee, you know, or not. Ada category there, right? So the degree of control is the one that you have to understand. Yeah, and you have the right to prohibit entry. So kalau lah kata plus tak nak bagi motor masuk just because dia dah buat perangai macam tu, eventually in other countries in Indonesia motorbikes tak boleh masuk highway because you cannot make a noise and saying that apa pula is highway, you know, you want to enter you pay. Like Philippine bikers nak masuk highway kena bayar. Okay, so that is what occupier means. Now an owner, sorry,
sir, just sorry, orang mesti boring I tanya je. Okay,
tak apa.
Okay, occupier, when we want to prove occupier in a test, in exam, whatever, we have to prove he has the immediate supervision, one. Second thing, we have to prove that he has a control and power, and then is either control and power of prohibiting or entering. These three, we have to do it separately, that it is applicable to this person, that he can be found as an occupier. Actually just one of them will fulfill.
Dia kata N kat sini, bukan O.
Right, yes.
So kalau N, you have to read them together, right?
But so, whether it's permitting or prohibiting, that is just similar words, right? So.
This is one or, perkataan dia or. So kalau dia pakai or, so permitting and prohibiting, there is a two-way. One is positive, permitting, one is prohibiting, negative. So remember, we used to go through talks 1, action that is positive or negative, right? So this is a positive act, this is negative act. Okay, passive or active, So it depends, it depends on the status of the question. So what you have to give is the definition, and then on top of that you are to apply the immediate solution, because the one that is down here is going to for us to identify each one of them. So any other questions from anyone else? Okay, the owner who has let the premise to the tenant is generally no longer the occupiers. So you have passed it over to him or her, therefore you are no longer responsible. But it is essentially a question of facts. So but still the law says that it is a question of facts. Just now the position that under the Lacken case, right? So he has given the rights to the manager. However, he has put a condition that he has retained the right to conduct repair works. Okay, once you have done that, meaning you want to have control, you don't release that control to somebody else. I normally in class I saja kacau budak-budak. I ada kononnya, if I have a house, right? Do I have the right to come into the house late at night? Say for example, the house is being rented to girls. Do I have the right to come into the house at 11 o'clock just to have a check? Is it considered
No,
as
no.
You
allowed?
have to
Yeah.
ask for the consent. I
You
think.
have to ask consent, kan? Because you have passed the what do you call it?
Reasonable
Control.
visit time.
Yeah,
Occupants
you
tracking.
have given that occupier ability to control, yeah, and that is the responsibility of that person. Coming to that, if you were to sewa hotel, right? Is it contractual entrance whereby you have every right to not allow anyone to come in, or macam mana?
Yes.
Kan? How about those maid coming into the room to make up the room? If you sewa 3 malam,
Mhm.
macam mana?
If you as an occupier has to ensure, in order for trespass not to happen, you have to put all your effort. So you put don't disturb or something. But if you don't put it there, then it's like an imply that you give the permission for them to enter. That's the status.
So actually, the situation is that both have joint control over the premise. You have joint control under contractual entrance. You pay money to be there in the room, and the management have every right to ask their staff to come into the room in order for them to do something. Obviously, not to steal your goods, obviously, but they are to be inside the room if they were to do any maintenance or to upkeep of that particular room. So you have to remember that this we are talking about joint occupiers rights, yeah. So
Sir, kalau
uh,
tak ada do not disturb thing was not available to the tenants of that hotel lah, yang apa visitor. So lepas tu tak ada button of do not enter or do not disturb or whatever. So and then you didn't lock the door, but you were inside and somebody get in to clean up the room.
You tengah tak pakai baju, right? What will happen? You rasa macam violated, right? So you kata you do not knock. I baru ni I tengok dekat hotel, dia tak knock, just masuk je dan nak hantar barang. I mean, I was like, wow, it's a high class hotel, and I was like, dia orang ni kena belajar ethics ataupun legal punya standing, because once you enter, obviously you tak boleh charge as occupiers, because you don't suffer anything other than your vanity ataupun your ni lah ni. So what you can do is nuisance, you can be utilizing nuisance as one of the mode that you can take action against them.
But you cannot do trespass for that.
Trespass because
the intention, right?
You have to prove intention. If you want to charge them, sorry, the word charge pun salah. If you want to take action, civil action against them for trespass, you have to prove intention, because that is the formula or the test that I've taught you about how to prove trespass. Of
intentional
land.
thought.
The intentional thought. So I think the first element is intention. So di situ kita kena we have to be aware, guys. You have to be aware of all the requirements of each area that we are going to do.
But sir, it's considered as that's the intention. You just remember, I mean, if I can recall that you mowed the lawn, even though you didn't intend, but the intention came from you moving that mower. You see, the intention for that person to come to your room is the intention for him to get inside.
But occupiers is very straightforward as compared to trespass. Trespass, you still have to have that test, right? Which is a task that you have to do, right? So if you have a choice, either occupiers liability or trespass, it is better for you to utilize occupiers liability, because it will make things simple for you to win the case. Kalau nanti kita tengok Ryland Fletcher, you put something that is dangerous in your land, and then that dangerous object escape to somebody else's land, causing them damages, obviously that person who suffered damages can sue you under negligence, right? Under thoughts of negligence. However, they would normally utilize Ryland Fletcher's rule in order for them to easily win the case. Because under this subject, what we are going to learn talks to, the subject is very straightforward, whereby you don't have to go through the nitty-gritty of getting things sorted out in order for you to prove your case. So,
But
yeah, sorry.
it's difficult with the concealed danger or whatever that one is. I don't like it. The concealed danger. I mean, something that you all have to know. That is very confusing.
That is a very gray area, and it is up to the court to have a reasonable man test, because they are the reasonable person, right? So it depends. It can swerve to left and right, up and down. It is up to them to decide, unless and until you come up with a certain. Because if you were to put it exactly as this is the definition, nothing else can come about, then you are doing injustice to the victim that suffered. Remember, Donahue and Stevenson cases before Donahue, all that suffered that goes to the court cannot claim because they have no contractual relationship. Just because the law says you must have contractual relationship in order for you to have a locus standi. So, but Donahue has changed the world because of the nature of the flexibility in terms of the ability to be subjective, rather than objective. So law has to be subjective. You, as the judges later on, you have to be subjective when there is no clear indication from the parliament. So why you have to trouble yourself and putting down your foot and saying that this is the only definition that I want? Remember, you are only one of the judges of all the judges there are in the system. So you cannot open for making mistake like that. So never, I'm teaching you not to, because if you were to do that, then fellow judges akan ketawakan you, and you will not go far. Okay, unless and until that you are in the federal court lah. When there is no law, then you have to create something, of a law. Okay. Owner has let the premise to a tenant who is generally no longer occupier, but still essentially a question of facts whether the landlord retains control or not. So here macam tadi rumah you ada kat luar, dekat kampung tak dijaga and things like that bila penghuni dah keluar. In Judge Chua, according to Judge Chua in China Insurance and Wu Hub, in applying to a control test laid down in Witt and Lacon, held that contractor of a construction site was an occupier of the premise. Look, the subject matter of a person that we in question here will be contractor. So contractor does not owe the land. They are there temporarily for the task that they were assigned to, assigned for. So they are there to do a job. And just because they were being allowed, the court says they are in control of the space that was given to them. Okay, so if you were to have a renovation of your house, when they come in, if they have created an object or something that is dangerous in nature that causing third party to suffer, then you can leave your responsibility and pass it to the contractor, saying that you have brought in all the tools, all the materials that is dangerous in nature. You should have taken reasonable step in order to prevent people from coming in. And in this situation, a person did come in for whatever purpose, maybe a theft, a thief, or a child. You owe that responsibility to that person. Okay, dia tak payah nak pergi negligent test. Dia kata, a duty. They go straight to the reasonableness for a person to have that particular foresight. Okay, so contractor. Now you know, contractor. In another case, we have Chang Falin. It was held that if a contractor is shown to have overall charge and control and possession. Nampak dia pakai and, charge and control and possession of a construction site, then he may be deemed to have occupation as well as possession of the site. Meaning, occupiers is lesser than the possession. Yeah, possession kalau kita belajar trespass to land, yeah, you are in possession of the land because legal or what do you call it? Apa dah lupa dah saya. You have that legal possession of the land. You are entitled to own that particular land because you are not the owner, tapi you have that possession. Yeah, possession in fact dengan possession in law baru saya tanya. Yeah, possession in fact is looking at the facts. You are in possession, but possession in law is by determination of the standard of the law that you have over that particular land. You are the possession in law. So the same thing here. It can be possession in fact or possession in law. And now it's more towards possession in fact, yeah, rather than possession in law. Possession in law is the owner of the land, yeah, that the what do you call it? The United Engineers is considered as possession in law of the land. The contractor, the contractor is considered as the possession in fact. Okay, so together with overall responsibility, meaning if you were to have actual possession in fact plus that you are the occupiers, then you should be able to have more increased degree of responsibility. So it is mentioned here actual possession. Pergi cari benda lain, dah ada kat sini. Actual possession is not required to determine the adequacy of sufficiently control because the occupiers itself, yeah, is more suitable for us to utilize occupiers liability because kalau actual possession, then you will have the possibility of suing someone under trespass, or in this case obviously trespass is not relevant, but actual possession is something that is not necessary, yeah, more or less. Let's look at this particular case. In Harris and Birkenhead Corporation, this local authority had acquired a house by compulsory purchase. This one may be because of the local authority have asked the cukai pintu or cukai tanah to be paid, but they tak bayar, so they acquired the rights over that particular place. And obviously what they did is going to evict the tenants lah, the previous owner, okay, or whatever tenants they are in that particular house. So the house was left vacant, and that is what normal being done by banks and municipal. They just do what they need to do, but the houses are left empty. And letih lah saya, banyak bukan letih apa, saya frust because kita ada so many houses that is abandoned, and we have so many people that is gelandangan, young people who doesn't have house. Please, you guys, you are going to be a leader of the society. Can you do something about it? If a person owns a house that they have left, then you can easily take control of that particular house because they have not been using it. So you took over that particular house, do renovation and pass it over to people, and the rental of that particular new person who gelandangan lah, katalah gelandangan, you, sebab dia orang tidur tepi jalan. You know, how cruel is the situation where dah lah kerajaan tak berikan kita, you know. So those people yang ada rumah, they just let it be, you know. And frustrating lah. Kita tengok bangunan ada berpuluh-puluh tingkat, beratus-ratus bangunan kosong. Do something about that empty space, and then give it to those people yang, you know, you have to do what you have to do lah as a government. Yeah? If you want to really take care of the society, you have to do. Yeah, and the law is in your hands. Yeah, so that is what I am saying, that I'm quite frustrated in this situation. They just took over the house and just let it be. After at a later date, what happened? A 4 years old child entered into the house and injured, yeah, while he fell from one of the windows. So the issue here is whether the defendant was an occupier, yeah, the local authority lah. And the court first held that the defendant had exercised his statutory rights to take possession, which is under any law. So you don't pay someone under contractual obligation or the provision that is provided under the law of the land. Agencies or individuals can take over your land, yeah, just like what the banks are doing right now. Dia peduli apa COVID, dia peduli apa orang tak ada kerja, dia peduli janji dia punya report to bank negara 6 bulan apa non NPL, non performance loans, and then they just want to take bankruptcy ke apa ke, you know. They are, oh, if I were to have a chance to be in power, all banks are to be closed, and then jadi centralized. It's all under government. Okay, the issue was whether the defendant was occupier, and the courts first held that the defendant had exercised their duty, statutory rights, yeah, that is the rights, bukan duty, sorry, yeah, and to control the premise, yeah, they have done that. Following that, they had immediately the right to control as soon as they took possession of the house, and therefore the occupier. Memang when is the date of they taking over the control? It is based on the decision of the courts. Okay, if they were to take action against someone for not paying the what they call cukai pintu, you know, uh, in that process they are not going to be responsible because they are taking possession. Once you have possession, then obviously you are responsible for that, irrespective whether you are occupying it or not. In this case, the house is empty and not being utilized by anyone. Dia tak letak pun dia punya staff kat situ. They just biar rumah tu under the process of mungkin lelong. Yeah? So the process of lelong will take some time, say for example 6 months. But during 6 months, you must be able to ensure that safety or any third party would not be able to enter into the house. Okay, so kadang-kadang kita tengok rumah terbengkalai lagi satu hal lah, that is another issue. Kalau kita tengok rumah yang diambil alih oleh bank, so they will leave it just like that, and abandoned houses, that the owners, the true owners, actually the banks. So actually you can sue because people, guys, people out there who did not learn thoughts, they do not know their rights. Okay, pencuri tak tahu dia punya rights. Kalau lah pencuri know their right, dia boleh saman kita, tapi obviously dia kena dia kena ambil apa, dia menang mungkin on the civil claim, but obviously the criminal is going to be there. Yeah, wallahu alam. Okay, so guys, kita habis berapa? 8:30, 9:30, 10:30, 11:30. Do you want to take a break if you want to? I can
boleh.
Sorry, yeah, you have to ask for break. I'm jenis yang jalan aja. Okay, so I know for the fact that you guys can easily go somewhere, you know, masuk air, minum air, makan sambil dengar. So I think I need a break. I nak pergi, my wife masih dekat dalam bilik. So I need to take a break first kot. Can we take a 15 minutes break?
Boleh,
sir.
Boleh ya?
Sure.
Okay, right. Thank you. Assalamualaikum.
Thank you, sir.
Thank you. Mm. Okay. Okay, semua 33 orang. Thank you for the break just now. Hopefully, do you have any questions that you want to ask before kita continue? Remember, macam Jamie dia suka tanya, Amy pun suka tanya, you know, but I'm worried about yang tak tanya. Bila tak tanya tu, I don't know, I cannot gauge because I cannot see your face. Kalau dalam classroom kita boleh nampak muka orang sama dia faham ke tak. Being a lecturer, kita nampak muka pun kita dah tahu kat mana orang tu ada. I cannot see your faces, so you have to give some indication in terms of your understanding. And how do you do that? Is by asking question lah. But I tak nak paksa kalau you rasa memang nak dengar saja, right? Okay, yeah, please do.
Assalamualaikum sir.
Waalaikumsalam warahmatullahi.
Saya just nak tahu apa since we are having ODL semester ni kan. So what is your expectation in question untuk talks 2 ni, so that at least kita dapat tahulah apa yang senak di dalam the answers.
Ya Allah, saya terlupa nak bincang yang tu kan. Saya. Okay, good. Thank you very much Farah for reminding. Okay, guys, I hope this one, the discussion is about your marks. Yeah, with regards to your marks, what you need to do is we are going to have groups. Yeah, so hopefully you are able to formulate or form your groups. Yeah. Groups of we have 40 with us, so group of 5, 5 pun dah banyak. Group of 6, yeah, 6 times 40 divided by 39 divided by 6 dapat berapa group? I'm not good at maths. Cuba tengok 39. I open up my calculator.
About 7 groups, about 7 groups.
Dapat 6.5 kan. So kalau kita bagi 6 group, 6 per group, berapa balance? 6 kali berapa kita dapat 39? 6 kali 6 36. 6, 7, 8, 9. So ada 3 group yang akan ada 7 orang, yang lain ada 6.
Bang, boleh bagi telur mata? Telur mata.
Dia nak makan telur mata.
This is good about ODL kan. We can be anywhere. And then kedai mamak pun okey.
Ali, boleh orderkan saya sekali tak? Order telur mata satu.
Dekat kedai saya.
It's okay. Bagus. Kalau lockdown semalam ronda-ronda, it's okay. Don't be sorry, please. Jangan kita rasa sorry on things that sepatutnya. Bagus. So okay, coming back untuk kelakar untuk kita punya carry mark. So there are few groups yang berapa group ada 6, 3 group ada 7. Ya. So 7, 14, 21, the rest ada 6. Meaning berapa group semua? Aduh, maths ni susah. 21 tolak 39. 21.
Apa 6 group lah?
39 tolak 21 kan, sebab ada 18. 18 bagi 6 18 bagi 6 3. Sorry. So ada 3, 6 group. So 3, 7, 3, 6.
Sir, must it be 6, sir?
I don't know.
Banyak ramai sleeping partner lah, sir. Seriously.
Tahu.
Preloaded sleeping partner, I don't really like that kind of dynamics, you know. So daripada bergaduh later, baik bergaduh sekarang. I think in my personal opinion, I think 6 is too overwhelming for a group.
Okay. So how many?
Now.
How many?
Maybe 3.
4 or 3,
to 4. Yeah, 3 to 4.
Okay.
I think quite sufficient.
Okay, good. 3 to 4. I'm okay with it.
So can I give a suggestion?
Yes, please. Any suggestion? This
So
is
maybe maybe we can put the maximum number is 6, depending on their students. For example, you can see the Amalina prefer 3, then it's up to her. But we put limit until lah, so it makes it easier for you to write up as well. Nak tanda pun senang juga.
Okay, bagi 3 to 5. How about 3 to 5?
Okay, sir.
Boleh
I
3
think
to
that's
5?
okay. Yeah.
Okay, and then kata lah. It cannot work with your group. You want to do it individually, then up to you. Okay, I tak nak pressure.
Great.
Nah, if you decide that you want to do it on your own, you can do it on your own. But the standard rule is 3 to 5. Okay. Why 3 to 5? Because as what Jamie is saying, Jamie here saya.
Saya tak suggest berapa.
Bukan Jamie. Siapa?
Amalina.
Amelina. Okay. Amelina kata, maybe 6. The tendency to abuse free riders and things like that. Yeah, I do agree. Okay. So one thing for sure is that hopefully this semester we are able to engage Turn-in as our medium of checker. Because last semester pun nampak macam ada redundancy. Tapi tak sempat. There's so many groups. I've got like 200 students under me. Okay. So, alright, done? Boleh? Right? So, question will be given to you hopefully next week. Yeah, and then the submission is going to be another 2 more weeks. So in the next 3 weeks, they are going to submit the first. I think, I don't know, I want to do 2 and then online, online. Dulu I dah janji untuk participation, right? So did I mention to you about my rules of participating in the U-Future?
Yeah, read it already.
Okay. 10 marks for that, and then 10 marks for online assessment in terms of you clicking and then answering. That is 20 marks, and then 20 for group, 20 for group. So we have individual 20, right? Because 20, the individual comprises of assessment. Yeah, you do online assessment in your future, and 10 marks for your participation individual. Yeah, so that both 10 plus 10 equals to 20 for individual. For another 40 marks comes from 20 assessment 1 and 20 assessment 2, and then the final 40 marks. Okay, any questions on that?
No.
Okay, good. Okay, Bismillahirrahmanirrahim. We continue the class. Right. We are looking at the case next to that case just now, Lembaga Kemajuan Tanah Persekutuan and Mariam. Okay, the court held that the defendant, statutory authority, Felda, remain as the occupier even when possession of the piece of land was given to a contractor, as the facts indicate that the statutory authority still retain control over the premises. Now,
sir, sorry, can I stop you that you can share the...
Oh, I see. Okay. I did not share. Just now I pressed stop. The whole thing. The whole thing when where is it? Hold on. Let me have a check. Seems missing. Aduh, technology. Sorry. Okay. Meet desktop. Cancel. Present. A Chrome tab. A window. Okay, let's look at the window. Cannot have that window. Present now, entire screen. Entire screen lah senang. Okay, now you'll be looking at the entire screen. Okay, can you see my entire screen right now? Okay, can you see? Okay, now. Alright. So coming back to the case of Lembaga Kemajuan Tanah Persekutuan and Mariam, what happened here is that the land owner would be Felda. Yeah. Felda, the owner of the land, have given that piece of land to a contractor to do something. Yeah. To develop or to create something lah, yeah. So when the land is given for development, normally the whole land is being passed down to that particular contractor to do whatever they want. Okay, so but if you look at the facts, yeah, here the facts of the case, yeah, it was not mentioned here, but obviously from the facts it can be discovered that they, meaning the statutory authority, IFELDA, still maintain some kind of control over the premise, yeah, by allowing their staff to go inside the premise, or by allowing evaluators, agents that belongs to the FELDA to come in to check, you know, uh, they have that ability to do that. So that amounts from the decision of the court that they still have control over the premise. Okay, especially when it comes to the Kongsi house issue of when it collapsed, yeah, where the deceased was the deceased suffered because of the collapse of the Kongsi house. It was built for the common of benefit of the defendant. Yeah, the defendant is for the benefit of the contractors lah, and the defendant in terms of the FELDA, to have people that can work for them, It's not only for the contractors, maybe because of the staff of FELDA can utilize that Kongsi house, for keeping materials and things like that, right? So you have to discover. This is where you, as lawyers, later on have to do some discovery in terms of the facts. Yeah. So just cannot accept the facts that is given by your client. So you have to do investigation. You have to do critical thinking, analyze the situation. Then in this situation, the fact that was put forward to the court says that because they had the control over the land where the Kongsi house is being used for the benefit of the laborers, for the defendant, for the contractors, yeah. So that is amounting to what they call it, control. And just because you have handed over that land by virtue of a document, okay, bila dia nak buat development, obviously they went into an agreement, right? Under the clause of that agreement, the land, the possession in fact is now passed over to the contractor. Even though it is stated, you remember that you learned dalam contract 1, whatever is written in the agreement, the court will eventually investigate. Yeah, so macam exclusion clause. Exclusion clause. Ami tolong mute ni.
Oh, sorry.
Alright. When it comes to tadi kat mana, dekat contract, exclusion clause, kita lompat sedikit contract, ya. Exclusion clause is always claimed by the defender saying that they are not going to be responsible because the plaintiff should have seen the exclusion clause and they rely on the exclusion clause in order for them to run from any liabilities. Yeah. So, but the court, before the court take any exclusion clause punya defense, the court will look at the facts of the case. Yeah. If they were to look at the facts of the case, then they will start to discover whether the exclusion clause is something that can be utilized or not. Okay, so that is the what I'm trying to say here. In Felda situation in this case, they might have come up with a document saying that the possession in fact is given to the contractor. Therefore, they have every right to run away from any responsibility. Obviously, in this situation that the court is saying that they are also responsible for it, yeah, in terms of the defendant, the contractor and the laborers, and the defendant did not cease in terms of the control, yeah, in terms of the possession, Felda, because this issue is about Felda running away from their responsibility, right? So in this case the court says, sorry, you are not excluded from the liability, right? So be careful. Yeah, sorry.
Excuse me, sir. Can I
Uh-huh.
ask you a question, please?
Yes, please.
That means the court will not directly honor any exclusion clause bound in a contract.
Yes. So remember, the court's duty is to give justice, right? So, and not to interfere, obviously. Yeah? When you have done a contractual relationship with another person, who is this court to become a busybody into that particular relationship?
I see.
Yes, that is the mode, right? You don't want the government agencies to be involved in your transaction between you and somebody else. But in giving justice, the courts have to evaluate the relationship by virtue of the premise that you want to utilize to run away from your responsibility, because they are the judge, because they are to determine both parties whether it is fair, contract is fair or not, things like that. It is in their interest. Yeah? So yeah,
that will be considered for good faith or not? The court will honor that as well?
to a certain extent, yes, to a certain extent, because sometimes if it depends on you belajar, nanti you belajar apa, you belajar juris, you belajar jurisprudence, how far that the role of the judges into meddling with other people's relationship. They have to, because we are not looking at Lim Kek Siang and UEM, because Lim Kek Siang is saying that they are the locus standi and saying things like that, right? We are looking at the judge, the mediator between the problem that is taking place between two parties. So obviously the court can easily say, oh, sorry, that is the agreement that you signed, too bad, but if they are in the mode of judicial activism, yeah, we call it under judicial jurisprudence is judicial activism, meaning the court play an active role which they are not supposed to by right, because the legal system that we choose to apply, it is not adversarial. It is not inquisitorial, it is adversarial, whereby the judge play a passive role. However, in order to find justice, there is a fine line that the judiciary have to play a role in settling the issues, especially when it comes to exclusion clause. Because it is subjective, right? It depends on the facts. Because kalau you parking kereta dekat satu shopping complex, and then dia kata sebelum you tekan mesin tiket tu, dia kata we are not going to be responsible for whatever happens to your vehicle. The management is not. That is normal, right? That is exclusion clause. So you tekan, you masuk, and then you enter into a contractual relationship. Dan bila you masuk sahaja that premise, the owner of the land owes a responsibility to make things safe for you. We are in the topic of occupiers liability. But as far as contract punya relationship, remember guys, bila you keluar nanti, you kena baca semua sekali. Semua semua law yang belajar ni kena keluar sekali. So if contractual relationship as an argument by the management saying that we are not going to be responsible. Siapa suruh you masuk? You yang nak masuk. Kami dah letak tanda dah. Tanda kami clear apa? Terpampang, tak ada sembunyi, tak ada foto, and then bila dah masuk, and then tiba-tiba ada banjir, because the pump not working. So dia kata kereta you dah flooded. So macam mana you nak claim? Dia kata apa ni? Dia kata excuse me, exclusion clause, you take the risk. So why should you blame me? So but the role of the court is to make sure from the facts whether it is okay for them to run away from their responsibility. Have the pump being maintained? Have things being done which they are supposed to be in the mind of a rational person? A rational management of a parking space, do they maintain the pump that is needed for water to be taken away from the parking lots? If it's parking lot yang atas, obviously tak ada pump, right? But kalau parking ada 5 layer bawah tanah, obviously you need that pump. Especially kita duduk dalam gurun Sahara, kita duduk dalam keadaan Malaysia yang memang hujan, raising season. That is the argument. Sorry, I belete panjang on that. So do you get what I'm trying to say?
Yes, sir.
Okay. So you as a judge later on, you must play your role within the boundaries that is being set towards you by the kelembagaan, right? And your kat meja, sorry guys, kat meja ground dekat guard tu, dia letak 2 meja. Blok 1. Kalau kita delivery tu blok 1 lah. Tak. Yang bawa ni. Tahu. Yang tu barang banyak ke tak? Kalau barang banyak, I turun sekejap lagi. Okay. Alright, coming back. You nampak So in this situation is not actually the possession but the control. Okay, how do you determine control? Because even though in writing that they say that now we don't have any control of that because we don't have possession, it is not going to be able for you to run away if the court says so. So the court ni dia mungkin kalau dia nak play active, nak ask you lah. Kalau dia nak play passive, then you selamat lah. You can always go to your exclusion clause, or terms and condition of the contract that you sign. So nasib kalau you case you dapat hakim yang jenis yang bagus, yang daring, then it's okay lah. Kalau hakim yang jenis banyaklah kerja KPI dia tinggi, then kata nasib siapa suruh dia tak tengok. Right, okay. Right, soalan? Good soalan. Ada lagi yang tanya? Right. So continuing, the significance of this decision lies in the acceptance of Malaysia that the order is to impose a duty of care and parties need not necessarily be in the pre-existing contractual relationship. Nampak tak? Dia kata, you don't need to have that contractual relationship. So, kalau you buat contract ke tidak ke, that is to be set aside. Sementara, dia discover the facts. Okay? Obviously, document is something that is going to be binding towards the parties, but the facts, the court akan tengok the facts. Okay, the court here in the case of Sri Inai Pulau Pinang Yong Yi Cui held that the landlord of premise stands in close proximity to the lawful visitors of his tenants. The duty may well be narrow than the own by the occupiers, such as tenant to the visitor, but is nonetheless present. Ya, apa maksudnya di sini? Landlord is always in proximity to the lawful visitor. Lawful visitor ni siapa? People that needs to do their job. Yeah, lawful visitors, licensee, entrance. Yeah, for example, people from municipal, people from the agency that are responsible for electricity, water, you know, they have that authority to come into that particular premise. So that particular duty is there. However, it is not. You cannot run away by saying that. Inilah senang ya. You ada rumah, you nak bagi sewa, and then you nak lepas semua tanggungjawab you, and then you sign satu document kata anything happen in that particular premise, I'm not going to be responsible. You have no way of linking me through either vicariously liable ke apa excuse you nak pakai tak boleh sebab dah ada agreement. Okay, setuju? Okay, saya bagi sewa. So but that does not mean that you are going to be able to run away from your responsibility, because there are people that is going to come into the house if they need to do so. Yeah, and macam tak adil lah kan. So you dah lepas dah rumah tu bagi orang lain sewa, mana you nak tahu apa dia buat? Dia bubuh paku ke, dia bubuh mainan orang masuk jatuh. Kenapa pula you nak kena responsible? But it depends on the facts. Yeah, it depends on the facts. Kalau lah facts tu regarding people that have the right to come into that particular premise, yeah. Say for example, you nak jual rumah tu, right? You nak bagi jual rumah tu, you panggil agent, yeah. So agent akan bawa potential buyers, yeah, to that that premise of yours yang ada orang tengah sewa, right? So you cannot use exclusion clause and say that I did pass over the space to you, so therefore I'm not going to be responsible. Excuse me, you have now give permission without the obviously tenant tak boleh nak kata apa lah because you nak jual rumah kan. So you dah bagi rights untuk your agent untuk bawa dia punya potential buyers, your potential buyers to the house to evaluate the house. Okay, ataupun you ambil position whereby involving realtor pula. Apa ni? Kita belajar faculty apa yang buat evaluation of house. Apa nama faculty yang kita belajar? Allah, duk nampak tapi tak boleh nak keluar ayat. FSPU, FSPU would be faculty that teach them their student to evaluate property, right? So if they were to come into your premise, irrespective whether it is a house or a land, so anything happen to them, don't you think that you are going to be responsible? Obviously, yeah. You look at the facts, yeah. So jadi kalau you nak make ensure that there is nothing going wrong, you have to go there lah. You just cannot simply lepas tangan. So you go there and make sure that everything is okay, safe. Kalau you pergi situ, you akan nampak, ni lubang, dulu saya bagi sewa kat awak tanah ni tak ada lubang ni. Kenapa ada lubang ni? Dia kata ni saya tengah korek untuk nak buat buang sampah. Saya nak tanam. Okay, fine, right? Tetapi apa langkah-langkah pencegahan yang you buat? So you are on behalf of the tenant as the owner, you must play an active role in order to make sure that you are able to say to the court, kata, excuse me, I put it in writing that he is supposed to be responsible, and I know that regularly I went there, I've checked the premise in order for me to at least do my part. For people when they come over, if they are rightfully have the right to enter, not to be injured. But if you say that I cannot foresee dia hari tu dia pergi cuci lantai dia, lantai dia licin, how are you able to control? It doesn't make sense. Takkan court akan kata, you kena jagalah sampai cara dia nak buat, nak basuh lantai dia tak licin. That is not within your authority to do so. Then is it reasonable for you to be responsible for somebody that came into your house tadi yang you dah rent kat orang and then injured? No. So it is based on facts. Yeah. Boleh? Kita tengok. Yeah.
So a quick question.
Yeah.
Okay, imagine this scenario.
Okay, Farah, you are leaving. Yes. Okay. Right.
Alright. This scenario, yeah, in terms of determining who is the occupier of the premise of the house. For example, you bought a new house and then you have served the loan, but then for of course when it's approved you have to serve almost immediately, something like that. Then you have you serve the loan maybe thrice dah serve loan bank, but then you still something pending, not on your side, but then on the bekas pemilik rumah dahulu, something pending at the land office, so tengah settlekan macam tu, and then for example have no key whatsoever to the house, but you have served the loan. Okay, so that's the scenario. And then let's say someone enter the house, okay, and then injure himself or herself there. So who will be responsible? You've served the loan, but then something is pending at the land office. Your name may not be there because the person before they have to actually settle whatever they have there pending. So the house is basically, the loan for the house is under your name, but then the name is your name is officially not yet there.
Okay. Officially, like what the house that I'm staying, I don't have title to the house. It is a title. The house that we are living right now for the last 8 years, we are not owners of the house. In law, under land act, under land law provision, we are not the owners of the land, because the land itself is belonging to another one chap, Malay chap, that owns this land. So that does not mean that I'm not the actual possessor. I'm not in control of my land or the house that I'm staying. So I'm serving government payment. So that alone is showing that in a way it is under my control. It is under my ability to control the house. Though you might say that you don't have the keys. You ingatlah kita untuk vacant possession, right? So in order for you to get vacant possession, the gray line between who is the owner, whether the contractor is the owner of the building, and they pass you a letter saying that come to the office, you now have the vacant possession, to get the keys in order for you to evaluate the house, ada crack ke apa ke. You did not respond to that particular letter, right, of the management or the developer. So can you run away and say that excuse me, I'm not going to be responsible for somebody who enters into that house which is not mine yet because I tak ambil kunci? No, because you tak ambil kunci, there must be a reasonable time for you to ambil kunci. Tapi kalau you dah 6 bulan tak ambil kunci, then you cannot run away and say that it's not my responsibility when people did suffer something in the house. So what the law is trying to say is that you are to do something actively towards your rights over a particular premise, a particular land. If you fail to do that, you cannot run away and trying to hide between some legal jargons and not be responsible. Oh guys, sorry. I have another class, another thoughts one, another 3 hours to go. So I will pass the video, inshallah. But guys, please make sure that everyone log out from this session. Otherwise, the recording will take like 4 or 5 hours. Then I have a big problem to edit the file because I don't have editor application in my computer.